A bankruptcy Chapter 7 is usually the simplest, fastest, and cheapest bankruptcy chapter available. It discharges debt, which is the legal term for canceling or wiping out debt. Chapter 7 bankruptcy gets rid of unsecured debt like medical bills, credit cards, payday loans, and personal loans, and various other types of typical consumer debt. It also discharges secured debt. Secured debt is where there is property that can be taken if you don't pay the debt. Typically, this is a car loan or a mortgage. If you owe money on a car loan, you can get the loan discharged in a bankruptcy, but if you don't pay for the car loan, you will not be able to keep the car. Does this mean that you will lose your car if you file for Chapter 7 bankruptcy? No, it does not, if you continue to pay for the car and catch up on any back payments. The creditor would much rather continue to get payments for the car and get you caught up on the loan instead of having to deal with repossessing the car. However, if you do need to get out of the car loan and you are willing to get rid of the car, you can discharge the loan, but you eventually will have to give the car up. The same thing applies to someone's house and their mortgage. You can file for bankruptcy and keep your house if you pay the mortgage and get caught up on any back due amounts, but if you don't pay the mortgage and catch up, you will still lose your house. However, if you are behind on your mortgage and you need time to get caught up with overdue mortgage amounts, that is often where a Chapter 13 bankruptcy can be helpful. A Chapter 13 is where you basically pay into a Chapter 13 plan, which allows you time to get caught up on the past due amounts on your mortgage. Since this video is mainly about Chapter 7, I will cover the details of a Chapter 13 in another video. So getting back to Chapter 7. There are some special types of debt that cannot be discharged in a bankruptcy Chapter 7. The ones that typically come up are domestic support obligations, such as child support, most court fines, and most taxes and student loans. In some cases, you can get taxes discharged if you meet the requirements of a fairly complicated set of rules that involve the expiration of several waiting periods and a detailed analysis of your tax transcript. Student loans in many cases cannot get discharged. However, there are some court rulings that have allowed for the discharge of student loans in a Chapter 7 bankruptcy if the person has made a good faith effort to pay in the past and meets hardship requirements as defined in the court cases. Even if some debt like child support, student loans, and taxes are not dischargeable, in many cases it is still worth it to file a Chapter 7 bankruptcy. That's because usually by the time most people are considering bankruptcy Chapter 7, they have a large amount of debt which is going to get discharged, and that helps them get a fresh start. So those are some of the basics of debt in Chapter 7 bankruptcy. Now I wanted to talk about property and bankruptcy laws. Bankruptcy laws allow people to keep up to a limited amount of property and money when they file for bankruptcy using a rule called exemptions. Exemptions are the legal term used to describe how much property and money you can keep if you file for Chapter 7 bankruptcy. If you have money or property that is worth more than the exemption amount, then the trustee can take it and use it to pay your creditors. There are different categories of exemptions that refer to common items of property like a car, money in the bank, clothing, furniture, jewelry, and various other items. Exemptions change over time because of changes in the laws, so if you are considering filing for bankruptcy, you should definitely consult with a bankruptcy attorney to see if you are at risk of losing your stuff. However, in most cases, that simply is not going to happen, since people filing for bankruptcy don't usually have property that is worth much and don't have much money, which is why they're filing for bankruptcy in the first place. But still consult with a bankruptcy lawyer to be safe. One property issue that is in a category by itself is the homestead exemption. The homestead exemption is designed to protect your home. You can exempt up to a certain amount of the equity in your home. Equity, in basic terms, is the difference between the value of your home minus the amount owed on your mortgage. If your equity is greater than the homestead exemption amount, then the trustee may decide to sell your home and use the proceeds over the exemption amount and over the administrative cost of sale and trustee fees to pay your creditors. That would be a disaster for most people and could scare someone away from filing bankruptcy Chapter 7. However, the good news is that in the state of Washington, where I practice as a bankruptcy lawyer, the homestead exemption amount under state exemption law is high enough so that the majority of people will not have to worry about losing their home because of too much equity if they file for Chapter 7 bankruptcy. Please note this only applies in the state of Washington, where I practice bankruptcy law. So if you are in another state, the Washington state exemption rules will not help you because you're in another state and different state laws apply. Also, if someone uses the federal exemption amount, which they can do in the state of Washington, they should know that the federal exemption amount is significantly lower than the Washington state exemption amount. So that could create a risk of losing their home if they have too much equity. Exemption rules are complicated. And this is another reason that you should consult with a bankruptcy lawyer and do not attempt to do it by yourself. Another issue that I wanted to briefly get into is the clawback rule. Basically, what that means is that if you transfer money or property within a certain amount of time before filing for bankruptcy, in some cases, the trustee can go after that property or money and take it back and use it to pay creditors. Getting into all the technicalities is probably going to be information overload, so I won't get into all of it here. The basic point is don't transfer property or money if you're thinking of filing for bankruptcy without consulting with a bankruptcy lawyer first. So now I'd like to talk a little bit about the Chapter 7 bankruptcy court process. A Chapter 7 bankruptcy happens in a few basic stages. The first stage is where you provide your information to your bankruptcy lawyer. There are about 50 pages or more of forms that have to be filled out in a Chapter 7 bankruptcy. They include information about your property, income, financial transactions, debt, and other financial information about yourself or your spouse if you are filing jointly. When you give this information to your bankruptcy lawyer, the bankruptcy lawyer will then put it into a series of different bankruptcy forms and schedules that have to be filed with the court. You also need to take a short online class that costs about $10 or $15 and get a certificate of completion before you file. Then after the case is filed, you take another class called the post-filing class, which also costs about $10 or $15 and can be done online, and you get a certificate for that as well that is filed with the court. When a bankruptcy case is filed, it is done electronically, and within about a week, the bankruptcy court automatically sends notices to the creditors that have been listed in your bankruptcy documents. The creditors get put on notice that the bankruptcy has been filed and they cannot continue with any collection activities or garnishing your wages or doing anything else to collect debt from you. About 40 to 30 days after you file for bankruptcy, there is a meeting that is called the 341 meeting of creditors. This is where you have a brief meeting with the trustee who has an opportunity to ask any follow-up questions that he or she may have about your bankruptcy. For most people, it is over in a few minutes, and the trustee just confirms your ID, your name, and that you've put down true information down on the bankruptcy forms. In rare cases, creditors show up and ask questions, but for most people, that just doesn't happen. In an occasional case where someone has a significant amount of property or has transferred a lot of money or property, the trustee will go into more depth to find out more information. However, for the majority of people who have little money or property, the 341 meeting is a simple, routine, short procedure. After a minimum of 60 days after the 341 meeting, the order of discharge is issued. This is the goal that is the whole point of filing for bankruptcy, which is to cancel your debt. Once that is done, you are now free of all or most of your past debt that has been weighing you down, and now you can get a fresh start. This is what the Chapter 7 bankruptcy laws were designed to do. So those are some of the basics of a bankruptcy Chapter 7. Like most things in law, there are a lot of rules to be aware of. So if you are considering filing for bankruptcy Chapter 7, you should consult with an experienced bankruptcy attorney. If you're interested in bankruptcy Chapter 7 in Western Washington, please feel free to call me. I enjoy helping people get a fresh start, and I would be glad to speak with you.